October's late plenary session at the European Parliament in Strasbourg saw the approval of new data protection rules for the digital age. The ambitious law was passed by a parliamentary committee that approved an updating of regulations for private citizens, as well as data handling by national security agencies. After almost a year and a half of negotiations, 4,000 amendment submissions, and more than 50 meetings, the data protection law was approved by the Committee on Civil Liberties, Justice and Home Affairs in Strasbourg. Officials say talks were difficult. The new data protection directive is politically sensitive because it deals with data handling by national security agencies, which is a member state competence. The regulation is commercially challenging because it sets rules for companies too. Together, the legislation is seeking to harmonize data protection across all member states and give users privacy by default, including the right to erasure.
The right to erasure is a right which exists in Europe since 1995. In all EU member states, it's law, and every individual has the right to ask for the deletion of his or her personal data whenever it wants so. But also there's a limitation, of course. If personal data are used for freedom of expression purposes, for media, press, whatever, then of course there is an opposition to that. And also if the state has the right to retain their data or a company. So there are some limitations to it, but the general approach is that individual rights are effective unless there is a ground to restrict them.
The data protection law saw a new gust of support in the same week. France, Germany and Italy denounced alleged spy tactics by the US's National Surveillance Agency, according to information leaked by the fugitive U.S. intelligence worker Edward Snowden.
Indeed, the strengthening of the EU data protection legislation that is ongoing, and we still need to have a final agreement between the Council in December and the Parliament, is an important element to the European answer to all these different spying scandals that we have seen developing over the past few months.
The spying scandal even went as far as eliciting calls from the European Parliament to halt talks on reaching a free trade deal between the US and the EU on grounds that privacy rules were still not agreed and trust had to be restored first.
Of course, the US is closely following what's happening in the European Union, like vice versa. I think that's normal, and that we are steering towards a transatlantic trade agreement and free trade area that shows how important it is that we talk about the question, what are our common standards when it comes to consumer protection, when it comes to environment protection, and also when it comes to civil liberties and privacy, for example. And I think that it's only normal that we ask the US as Europeans to also deliver on those questions in parallel to these trade negotiations.
The US's overseas surveillance tactics, US and the EU's free trade talks, and the EU's proposed data protection laws all seemed previously more unrelated. But as the question of personal versus state privacy becomes more relevant and prevalent, all these issues have begun to converge, and important questions about the future of privacy are being asked. Sandra Gottman for JN1 at the European Parliament in Strasbourg.